Hello, and thank you very much, everybody, for attending today and taking time out of your busy diary. It's great to see so many of you interested in the new Procurement Act. For those of you who don't know me, I'm Stephanie Rickard. I head up the procurement team at VWV, and I'm going to be co-hosting this session with Matthew Wolton, who is a commercial partner specializing in Academies, and Isabel West, who is one of our junior solicitors in the procurement team. So I know we've been talking about procurement reforms for several years now, but we finally have an anticipated date of the 28th of October. So the recent election has put a slight spanner in the works in terms of the information that is being provided by the Transforming Public Procurement team, but they have said that they expect preparations for the Act to continue as normal. Legislation is being rushed through, and there is plenty of information on their website. In terms of what we're going to cover today, we thought it would be helpful to provide an overview of the Procurement Act and look at the changes that have been made to the procurement regime. And I'm going to talk a bit about some of the recent developments and updates from the Transforming Procurement team over the last couple of months. Matthew's then going to talk about the particular issues that the Procurement Act means for the AMS sector. And then we've got a number of polls coming up as a bit of fun, and then some top tips in terms of what you can do to get ready. So this section is about the legal framework, just to understand how the bits of the jigsaw all fit together. So one of the aims of the reforms was to simplify and consolidate the procurement legislation so that the public sector regulations have now been consolidated with the concessions contract and the utilities contracts regulations, all into the Procurement Act. So the Act is definitely shorter. It's now 126 pages long, but it's a framework piece of legislation which has to be read in conjunction with other regulations. So the procurement regulation sets out a lot of detail about the noticing provisions and also the CPV codes, and the procurement regulations is 105 pages long. So you can see that it's not that much shorter. Now, as I said, there has been a lot of legislation rushed through as a result of the regulations. So the Procurement Act 2024, Commencement number 3, has just gone through. And so the framework is now in place for the Act to take effect on the 28th of October. On the next slide, I've set out some of the procurement framework, but just to note that it's non-binding. So there is a national procurement policy statement, which you need to have regard to, when you're considering starting your procurements. Now, there's a new one that has been published at the end of May, which comes into effect on the 28th of October. We'll talk about that later. There's also a raft of guidance documents on the Transforming Procurement website. These are very interesting, actually. They're very helpful. So there's a section on the transitional arrangements, there's a section on the light touch regime, but it's important to note that they're not statutory, so they are not binding, but they're useful in terms of setting out the intention of the legislators. So in terms of the overview of the Act, I started setting out the key features and decided that actually it works quite well as an A to Z. So here we go. So A is for a new regime. It's going to look quite different to the previous or the current procurement regulations. Actually, in terms of changes, there are a number of set pieces in changes, but there's an awful lot of tweaking round the edges and a lot of detail that we're having to get to grips with, actually, in terms of understanding the changes. So one of the aims of the Act is to bring about a behavioural change, and this is linked with transparency. Isabel's going to talk a bit more about the notices, but you're going to you'll realise that there's going to be a lot more notices that will need to be published throughout the procurement life cycle. We've talked about consolidation of the regulations. D is for debarment and E is for exclusion, and they really go together. One of the important changes under the Procurement Act are to tighten up the grounds for excluding bidders before you even consider their tender responses. And this has been in response to complaints that the exclusion grounds are difficult to apply in practice, or, for example, in relation to poor performance. We often hear from academies that it is very difficult to apply that exclusion. And so there have been quite a few changes to the exclusion regimes, and some mandatory grounds have been added. But the thing that's important to note is that there is a duty upon you as contracting authorities to check the debarment list when you're deciding, when you're looking at a tender response, to see whether a supplier has on the debarment list. And this is going to be a central register that is being held by government. I think it's not actually going to be held on the same site as the or the other tender information, which I'm not quite sure why, but that's the current information. If they're not on the exclusion list, but on the debarment list, but you decide that there are grounds for excluding bidders, and you decide to go on and exclude a bidder, then you need to inform Cabinet Office so they consider whether to put that supplier on the debarment list. The other thing that's important to note with the grounds for exclusion is that the grounds are extended not only to key subcontractors, but also to connected persons of the supplier. There's been a lot of discussion about the new competitive flexible procedure, and I think this is one of the real good points about the Procurement Act, where you can design your own procedure to fit your requirements. So it'll be much easier to carry out, for example, demos for IT tenders, or to include a best and final offer stage, or to carry out interviews. The caveat to that is that you need to set out in advance how you are going to carry out a process and then stick to it. We've talked a bit about greater transparency, not only in terms of the notices that have to be published, but also in terms of contracts that need to be published at the end of a process. For the public sector, there is a slight tweak to the horizontal and vertical agreements, but that's not so much relevant for you as Academy and maintained schools. Interim order refers to the power of the court to make an interim order if a procurement challenge has been launched, in order to, it has a range of remedies in order to stop a contracting authority from taking any further action in relation to a procurement process. Direct award justifications are now set out in Schedule 5 of the Act. Actually, if you look at Schedule 5 of the Act, the justifications for direct award are fairly similar to under the existing Act. All right, so going down to the second half of the alphabet, KPIs. So if you have a contract which is over 5 million, and I suspect there's going to be few in the sector which actually of that value, but there's a requirement to introduce 3 KPIs into your contract. L is for life cycle, because the procurement life cycle has been extended under the Procurement Act and starts much earlier. So, for example, there may be a requirement for you as academies and maintained schools to publish a procurement pipeline yearly in advance of your procurement activity, and then the life cycle extends to market engagement. It goes all the way through the procurement process, and there are new obligations in relation to contract management. So really, it's a much longer scope of the regulation. Contract modifications. There are some tweaks to the grounds for being able to modify a contract. And it's important to note that when the new rules come into place, if you want to make a contract modification that is caught by the rules, you will need to publish a contract change notice. Talked about the National Procurement Policy Statement for N. O is for open frameworks. There's been a lot of publicity about the open frameworks, and in theory, it means that frameworks can be valid for longer. Essentially, an open framework is the possibility to introduce new competition onto a framework at various stages of the framework process. The central digital platform is going to be an enhanced version of Find a Tender, and it will publish all the notices in the normal way. But also another functionality is that all the supplier information that would normally be provided by way of the selection questionnaire will now be provided digitally on the central digital platform. Now, this is one of the areas where I think government are catching up. This won't be completely ready by the 28th of October, but the functionality that you will need to start off a procurement process, I understand, will be available. So Q is for selection questionnaire. That's a bit of a cheat because really they're now called conditions of participation. R is for remedies. There are some interesting tweaks to remedies in terms of there are slight changes to when you can obtain a set-aside, previously called ineffectiveness remedy. And assessment summaries are really important because that is the information that would be provided to unsuccessful bidders after the evaluation process, which provides a lot more detail than currently under the standstill letters. Below threshold contracts, there are new rules that apply to below threshold contracts, and U and Y are really for utilities. Actually, dynamic markets is the new name for dynamic purchasing system, but it's a completely different concept. They've introduced the system of qualification under the utilities regime. Okay, so hopefully that's a useful run through of the key features. Just then, in terms of recent developments, so you may recall that there were 2 consultations last summer in relation to the procurement regulations, and the responses to the consultation and the regulations have been published. So there have been some tweaks being made to the regulations which are aimed to be less burdensome. So previously, when a contracting authority had to publish an assessment summary, there was a requirement for a contracting authority to include in the assessment summary the reason. So for example, with a score of 0 to 5, if a bidder had scored 3, then previously there was a requirement for you to include a rationale as to why the bidder hadn't achieved the higher score of 4. That has now gone, so that should make making the assessment summaries a lot easier. But point to note that actually the assessment summaries are going to be more or less in the form of the evaluation matrix. So there may be some work to do in reviewing your evaluation matrices. So the contract award notice is the notice which is published after the assessment summary, which says, by the way, to the public, we are intending to award a contract to a successful supplier, and this triggers the start of the standstill period. And previously, there was a requirement for all unsuccessful bidders to be listed in the contract award notice, and there was concern that this might put off bidders from bidding, particularly SMEs. So that requirement only now applies where the value of the contract is over 5 million. Okay, so as I said, the procurement regulations have now been published. It sets out all the information that suppliers need to put on the central digital platform when they are bidding for a contract. Now, I've heard that this information, or the ability to add information, is not going to go live until quite late. So if you're thinking about issuing a procurement under the new rules, then you need to allow for the fact that suppliers will need to have time to insert their information on the platform. It sets out all the detailed requirements for the notices, and it includes a complete list of CPP codes. I think that's really helpful, not because it means that there's a one point of reference, but also they're a lot more detailed, so it's easier to work out whether something's light touch or whether it's subject to the full scope of the regulations. The guidance notes I've mentioned, there are 17 published to date. The original intention was that the full suite of documents would be published by the end of June. I don't know whether the election is having an impact on that. Some of you, hopefully a lot of you, will have signed up for the e-learning course that is available through the Government Commercial College. And I've mentioned the National Procurement Policy Statement, which has been issued and was applied. It's not there's nothing in there that's rocket science. It talks about complying with 4 basic principles, which is to comply with value for money, to comply with social value, to think about SMEs, and to think about skills and capability. I'm now going to pass over to Matthew, who's going to talk about the transitional provisions under the Act.
Many thanks, Stephanie, and hello, everyone. So the transitional provisions, as Stephanie said, we're due for the new Act to come into force on the 28th of October, but of course, nothing is ever simple, so we have to deal with the transition from the existing public contract regulations, the PCR, over to the new procurement provisions. And the headline provision is that the current regulations, the 2015 regulations, will continue to apply to any procurements commenced or awarded prior to the 28th of October, of course, assuming that we are going to proceed on the 28th of October. So any contract that you have procured and got in place now or before 28th of October is going to continue to be covered by the existing 2015 regulations. And anything that you start before 28th of October. But of course, what does start mean? Does it mean you've just started thinking about it? You've carried out some basic supplier market due diligence, some cold conversations, etc.? No, the rules are that there is a narrow definition for what a procurement, what it means when they refer to a procurement having commenced, and essentially it's about publication of a notice. And there are, of course, many different notices that can be published. You might have provided the lightest touch of notice, a PIN or prior information notice. The issue here is that we're already out of time on that. In order for a PIN to be a valid commencement of a procurement process, it would need to have been published by the 26th of May, 2023. So unless you have a PIN which has been published, that's out of time. If you publish a contract notice before the 28th of October, that is the most usual scenario where we will see procurements having been deemed to have been commenced and therefore locked in under the current regulations. So publishing a contract notice before 28th of October means you will continue to be covered by the 2015 regulations. If you've published a voluntary transparency notice, same scenario, it's dealt with under 2015. And also technically, if you are carrying out a below threshold contract, procuring a below threshold contract and you've published a notice in Contracts Finder, that would count as being a commencement. But of course, the sector doesn't need to publish in Contracts Finder. On that basis, it usually doesn't. So that's unlikely to be so important. Just covering all bases, if you were to be using the negotiated procedure, again, something which we don't find used very much in this sector, if you've notified the supplier of the intention to negotiate, that would constitute commencement of a procurement. So those are the contracts that will be covered by these transitional provisions. And the important thing is that that means they are subject to the 2015 regulations for the entirety of their lifetime. So if you have a contract that starts on, say, the 1st of September and is set up to be a 3-year contract, for the whole of those 3 years, it will be governed and ruled and regulated by the 2015 regulations. One key part of that is modifications, changes that you make to the contract, whether that's changes in terms of amending the scope, adding services, taking services away, whether you're extending the contract, etc. The modifications, for those of you that have listened to me before and are familiar with Regulation 72, those are the rules that will apply for the lifetime of the contract. Clearly, that is helpful for those people who are happy and comfortable with the current set of regulations. It pushes back that time that you'll need to work with the new regulations or the new Act, and hopefully by that time the position in the market will be a lot clearer. Framework agreements and dynamic purchasing systems. Frameworks are commonly used within the academies and maintained schools sector. And again, what the transitional provisions mean is that if a framework agreement has been set up, or the procurement of the framework agreement has been commenced before 28th of October, that framework agreement will continue to be regulated by the 2015 regulations. And that means that all call-off contracts that are made under that framework agreement will be considered and dealt with under the 2015 regulations. Framework agreements can be set up for 4 years. So if you have a framework agreement that, for example, goes live on the 1st of September this year, that framework agreement will run for 4 years. And of course, call-off contracts that can be taken out at any point during that 4-year term can last for an indeterminate period after that. So we could be looking at a substantially lengthy period of time where you will be having to deal with 2 sets of procurement rules, one for 2015 contracts and one for new Procurement Act contracts. So it's important to recognize and understand that we're going to have a considerable period of time where we will be dealing with both sets of rules. Guidance document has been published. It's useful, it's helpful, as Stephanie said. It's one of the suite of documents that are in the course of being published, and is well worth having a look and going through. If we move on now, we start to look at other issues that are particularly relevant for the academies and maintained sector. As Stephanie said, one of the biggest changes in the new Act is a move towards more flexibility, less restriction, less shackles being placed on you when you're carrying out your procurement. The quid pro quo for that, in return, there has to be greater transparency. There are more notices to be published, and that is something that the academies and maintained sector will need to get on top of and need to make sure that they don't fall foul of. I'm going to come back to that shortly because, as it turns out, it's maybe not so bad. A lot of you will have heard of pipeline notices, and this is essentially a way of letting the market know what you are going to be doing. What contracts have you got coming up? When does your current IT contract end? When are you going to be procuring a new one, etc. There's been a lot of talk about this because although currently it's considered good practice and is recommended for all contracting authorities to have a pipeline notice, it's only been advisory up until this point, but it's now become mandatory. So there are a lot of concerns about what this means and a lot of worries about what's involved. Now, I think it likely that there aren't going to be too many multi-academy trusts and maintained schools that are going to be subject to this. Because if you see the points there, the requirements to publish pipeline notices only apply if your pipeline over the next 12 months is going to be over £100 million. And when calculating that £100 million, you only take account of contracts that are worth over £2 million over a period of 18 months. So I'm not aware that too many schools and trusts are going to have that many contracts over £2 million, which cumulatively over 12 months come to more than 100 million. Just to note, the 12-month period that refers to is unhelpfully the local authority financial year, April to April, rather than the year which we all work with in the sector, 1st of September to 31st of August. Again, I don't think that's likely to be too much of an issue. If by any chance you are lucky enough to be in a position of spending over £100 million in the next year, you have to put that first pipeline notice in place by 26th of May next year and annually thereafter. I talked before about framework agreements. I want to come back to them here simply because I know how useful a lot of schools and trusts find using framework agreements. It takes a lot of the worries and concerns off your plate for running a fully compliant procedure. But I would be remiss if I didn't bang my usual drum about this and remind everyone of the 3 golden rules when using a framework agreement to make sure that you are in fact covered and it remains a compliant call-off. The first is to make sure that you are in fact entitled to use that framework agreement. framework agreements are set up and they have to specify what bodies can use it. Make sure that you, whether you're a school, whether you're maintained, whether you're an academy, are one of the named parties that's able to use that. Secondly, make sure you follow the rules. A framework agreement will have within it the specific rules that you have to follow to call off a contract. And whether that's a direct award or a mini competition, you must make sure to follow those rules closely. And that includes using the standard call-off contract terms and conditions that will be part of that framework agreement. Go too wild, too off-piste, and you risk that being a non-compliant contract. And finally, and this is even more important now, given what I said about the transitional arrangements, and given that these framework agreements that we're comfortable with now are going to be running, they are likely to be popular. A framework agreement, when it is set up, will have a maximum value of contracts that can be called off. If contracts have been called off that reach that value, there is no more space left on that framework agreement. You can't use it. So it's very important that you check with the framework operator, what are the value of contracts that are being called off, and is there room still left under the framework agreement for you to use it? Moving forward, the good news, there are several parts of the new Procurement Act which aren't going to apply to academies and maintained schools. One of the things that the new Act does is include payment terms that set out that every contracting authority, whether or not it's included in the contract, has to pay invoices within 30 days. It's something that you will see a lot in your contracts anyway, but even if it wasn't there in the future, for contracting general public bodies, those terms are implied. But not for you. There is no implication you are exempted from that, so there is no requirement for you to pay within 30 days. Of course, there is nothing which stops you from paying for 30 days, and if you agree a contract with a supplier that says you have to pay within 30 days, then that will be the legal obligation you're under. But one of the things that suppliers who work in the public sector may well try to say is that it is a requirement of the new Procurement Act that they are paid within 30 days, and that's not the case for schools. In terms of payment compliance notice and contract payment notices, again, similarly to the current position that you are exempted from having to use Contracts Finder and publish notices in Contract Finder in the majority of scenarios, again, that will apply. And Stephanie mentioned before that there are rules for and the new Act brings in rules for how to deal with below threshold contracts. So for majority of services that you're going to be looking at, anything worth under £214,000, including VAT over the lifetime, those rules again do not apply to the academies and maintained school sector. So it's good news. A lot of the additional transparency rules and regulations and restrictions won't apply to you. And that brings me to the last slide I want to cover, which is about the light touch regime. And the important principle here is that the light touch regime is similar to what it is now, but has been slightly tweaked and developed. As the slide says there, new guidance has been published. It's worth reading. But the key principle here, as it always has been, is that various services are deemed light touch and therefore not subject to the same strength and precision and requirements of the regulations for if you're entering into contracts to buy them. And the first question is, what are these light touch services? As Stephanie said, they're now helpfully set out in full detail in the various acts and regulations. So it's possible to check the CPV or Common Procurement Vocabulary Codes to make sure that what you're looking at is or isn't a light touch service. The ones that we've pulled out that are generally relevant within the sector: primary and secondary education services, education and training services, vocational secondary education services, and catering services. These are the usual ones that we come across working with schools, and these are light touch services. So what does that mean? The primary point to note is that it's about threshold value. The threshold value for normal services, 214,000 and a bit of change. The equivalent threshold for a light touch contract is £663,000. So any contract for these services that is £663,000 or less is a light touch service. It's below the threshold value for light touch services and therefore is not subject to the same requirements that it would be if it was over and above that. The other point to note is the threshold value for school catering services. We do quite a lot of work with catering contracts, and in the main, in the academy sector and the maintained school sector, they tend to be concession contracts. So that although you pay directly for things like free school meals, for staff services, for ad hoc services, etc., the bulk of the income, the bulk of the value of that contract is generated by the caterer supplying meals directly to children. If that's the case, that's a concession contract. And a concession contract involving light touch services has a threshold value of £5,372,000. So again, if you are under that value for a catering contract and it's set up on a concession basis, that's not going to be something that you are going to be covered by the same rules and regulations that you would be for a normal contract. So a lot of our work goes on advising whether or not services that are being provided constitute light touch services, because if they are, it generally transpires that the weight of the procurement regulations don't need to be followed to the same extent. If for any reason it was a threshold, it was an above threshold procurement of light touch services, there are, as I said, it's a lighter regime. You're not required to follow, for example, you're not required to have a mandatory standstill period. Although we would always recommend following one, it avoids or it reduces the likelihood of challenge, and it also means that you avoid the risk for having a contract set aside. If you have a light touch contract, modifications don't require the publication of a contract change notice. It's up to you to determine how the procedure that you're going to follow is going to work. You do have to follow it, but there's a significant degree of flexibility in how you do that. So generally, light touch services, make sure that what you're dealing with is a light touch service. If it is, the likely value of that contract is going to be below threshold, in which case you are not subject to the requirements in anywhere near the same of control. If you have a mixed contract, final point, if you have a contract that has an element of light touch services and an element of non-light touch services, the rules now relate to if the non-light touch services can be distinguished from the light touch services. If it's something where the non-light touch services and the light touch services can be dealt with separately, the expectation is that you would procure the non-light touch services in the usual way. So, for example, if you have a mix of light touch and non-light touch, and the non-light touch is over, say, £230,000, and it can be procured separately, you would be expected to procure that separately, and then the light touch service would follow the light touch regime. So that's really looking at some of those transitional periods and light touch services. And I'm going to hand over now to Isabel to talk you through more details on notices.
Thanks, Matthew. Hi, everyone. I'm Isabel. So I am going to chat through the new notices regime. So obviously we know that one of the key aims of the new Act was to improve transparency. And they wanted to make sure this was improved throughout the whole life cycle of the procurement. So unfortunately, this means the number of notices that you will be required to post has increased from 2 to potentially 10. So there's a massive increase. So what we've done here, we've split standard procurement, it was a above threshold regulated procurement, into 4 main stages, so you can sort of see what notices you'll need to consider at each stage. So like Matthew said, this takes into account the schools exemption. So if we start in the planning stage, the first one is Sorry. First one is the pipeline notice. So like we said, this will only apply if, sorry. Sorry. Yeah, so this will only apply if you spend more than 100 million on public contracts in the coming financial year. So I don't know how many of you this will apply for. The next one is a planned procurement notice. So this is an optional notice. So this is similar to the PIN notice, which is what we have at the moment. And it basically just informs the market that they intend to publish a tender notice in the future. So a preliminary market engagement notice. So this is if you intend to or have already carried out market engagement, you need to publish this notice basically just to let the market know. So if we go on to the procure stage, we have the tender notice, which is what we currently call the contract notice. So it's a bit of renaming. And this is basically just posted to commence the procurement. Similarly, we've got the transparency notice, which used to be called the VEET. This is used when you intend on going through direct award. So the actual contract award stage, the contract award notice, like we've mentioned previously, basically just sets out that you're intending to award the contract. And it's done after you've done the assessment stage. A procurement termination notice. So this is a new notice and it's quite a big change to the current regime. So you are required to post this if you start a procurement and then decide to terminate it halfway through. I know that we've advised quite a lot of academies on stopping procurements halfway through. So this is definitely one to keep in the back of your mind. I think it'll be quite an easy one to forget to do, but it's important. The contract details notice. So this one's a bit complicated as always. It's basically a notice that you're required to post, and it contains details on the contract basically. So it's the final value or the duration. So if you're posting that in regards to a light touch contract, you are required to publish that within 120 days of the contract being executed. For non-light touch contracts, that time limit goes down to 30 days. So there's quite a big difference. Also, if the contract you're posting about is over £5 million, you're required to publish a redacted copy of the contract within 180 days. So there's quite a few time limits and values that you need to be aware of for that one. And the final stage is contract performance. So the contract change notice, that's got a little asterisk next to it because this doesn't apply to light touch contracts. It's basically if you modify contracts and that modification changes the contract value by more than 10% for services and then 15% for works, you're required to post this. But like I said, not for light touch contracts. Similarly, for a contract performance notice, this isn't required to be posted for light touch contracts, but it's a notice basically setting out whether they've performed against the KPIs which have been set. Finally, the contract termination notice. So this is different to the procurement termination notice, and it needs to be published within 30 days of a contract being terminated. So as you can probably see, increased transparency does equal increased admin, unfortunately. So it's definitely worth trying to get to grips with the notices now, and sort of figuring out which ones will be needed at each stage. It's also important, I think, to remember that you'll need to consider for each separate procurement which notices are required. It'll be dependent on things like whether it's a light touch contract or the value of the contract. So yeah, it's best to do it on a contract by contract basis. So now to test your knowledge, we're going to do a quick poll if I go onto that one. Okay, so in this one, there are at least one fake notices. So if you want to answer the poll to see which one you think is the fake notice. It's a clear winner so far. We'll just see if a few more people. There we go. Yep, so you are correct. The debarment notice is the fake poll. So there surprisingly isn't a notice for that. There's a notice for everything else, but the debarment, it will just be a debarment list. So let's go to the next one. So like I mentioned, there's quite a lot of new terminology in the new Act. So what will these phrases be called under the new Procurement Act? So the first one is ineffectiveness. What is that going to be known as? And then the second one is standstill letter. Okay, so we've got a draw on the first one, a draw between rescind and set aside, which is interesting. But the correct answer is set aside. So instead of a contract being deemed ineffective, it will now be known as it being set aside. So the second one, standstill letter. So this is pretty much a draw between all three of them, which probably just shows how confusing maybe the new terminology is and how many new notices and everything there are. So the correct answer for this is the contract award notice. So yeah, I think it's just important to try and get your head around this new terminology. So I think now I'm handing back over to Matthew.
Thanks, Isabel. So what can you do to get ready? And I think those last polls just underlined how confusing the new rules and regulations can be. We've had quite a long time under the 2015 regulations, but it does feel now as though they were lovely and comfortable. And that's perhaps something we only feel when things got to get taken away. But in terms of getting ready, I suppose the first thing to say is the most obvious. It's about getting ready. It's about reading. It's about familiarizing yourself with the new rules and the new Act. The Act itself is published, but as has been referenced, particularly by Stephanie, the important thing is the guidance that has come out. There's a lot of guidance that's been released. There's a lot of guidance that will continue to be released. Helpfully, I would say that actually a lot of this guidance is written on with a fairly practical leaning on it. So it's worth downloading those guidance notes. It's worth reading them, and it's worth, as Stephanie referred to, the e-learning options that are available there to look at. I said before, I think it unlikely that there's going to be a lot of pipeline requirements for the sector, but if there is, you do have to start getting that ready and getting that in place. You are going to need to update your procurement policies and procedures. You need to make sure that you have those built up in time. October is coming remarkably quickly. It's certainly, we're in the last push before summer holidays, and then we start again in September, and October will be on us before we can breathe. The Academy Trust Handbook is an interesting one. We are currently on the Academy Trust Handbook 2023. We would have expected the 2024 handbook to be published, We've had confirmation that it's not going to be published until after the election. There are a number of points within or proposed changes to the Academy Trust Handbook which are going to need ministerial sign-off. It has been decided that that can only be signed off by the new government. I am slightly cynical. I am slightly worried about when this is going to happen. I cannot see it. And if we have a change in government, which I think we all think is likely, I can't see their first priority being to sign off a new Academy Trust Handbook. So when that Academy Trust Handbook comes into play, given that the election is going to be a matter of a couple of weeks before most of schools break up, they then come back, at which point the new Trust Handbook would be expected to be in place. We are likely to continue with the 2023 handbook. And yes, you're going to need new templates, new terms and conditions. Start engaging with your stakeholders, start engaging internally with the members of your team, start engaging externally with your providers, suppliers, etc. And yes, get familiar with that central digital platform. It's going to give you a lot more information. It's going to require more information from you. So make sure you understand how it works. So as and when it's required, you're in place, you know what you're doing. And I think I'll now hand back to Stephanie.
Hello again. We just thought we'd run a poll to see how ready your organisation is for the Procurement Act, and I'm very grateful if you could just spend a minute completing this, because it helps us work out our offering in terms of procurement support. And actually the final slide of this session is ways in which we can help you get ready for the Act. Brilliant. Okay, I mean, that's interesting. Between 52% said they're not yet started. So as Matthew said, there's quite a lot of work that's involved. I mean, there's quite a lot of work just to get familiar with the changes and then to implement the changes within your academy or maintained school. And a long way to go, 45%. Yeah, I mean, to be fair, I think that's probably consistent with some of the reports that we're getting from public sector and other education institutions. So in terms of what we can do to help, we have a specialist team, procurement team at VWV. So we've got non-contentious lawyers as well as contentious lawyers. So we're all having the process of getting familiar with the Act and having detailed know-how sessions to get up to date. We've got some short podcasts coming soon on key features of the Act. So Isabel and I have done one recently on the exclusion and debarment regime and how that's going to work in practice, and hopefully they will be very useful to you. They're aimed at being very practical. The Procurement Act helpline, we're looking to introduce a helpline if you don't already have the benefit of the wider retainer offering for schools. You might want to consider about having Procurement Act helpline, which is to help if you've got queries relating to the Act and to in that crucial stage in September, October, to help with queries that you've got regarding interpretation and putting processes in place. And we'd be very happy to help with support in terms of updating your templates, policies, and procedures. So going now on to the questions, I'm just going to have a look to see. We welcome any questions from you on the presentation or on the Procurement Act more widely. So we've got one question in at the moment saying, do you have any suggested procurement policies that incorporate the new regulations? We haven't got any template policies because obviously the policies would tend to be bespoke to individual organizations, but that's something that we could have a think about, seeing if there is something that we could do to help. So thank you for that suggestion.
I hope this means people thought there's a lot of information in the webinar rather than being overwhelmed and punch drunk.
So we've had a suggestion in that someone would find it helpful if we went through maybe the must-haves in any policy.
I mean, I think one of the things that is just as a starter for 10 is worth thinking about is, as we've talked about, a lot of the language has changed. So you've got the SQ now becomes conditions of participation. You've got assessment summaries instead of standstill letters. You've got contract award notices, which aren't contract award notices. So as a starter for 10, there's a job to do in simply making sure that the terminology that is used is being consistent.
Okay, so we've had another one about the pipeline notice. So given the pipeline notice is April to April, with the first notice in May 2025, is there a requirement for publication of contracts between October 24 to April 25?
No. That was an easy one. Yes, the position starts effectively in May 2025. So you have, I should have worked this out rather than using my fingers, 8 months or so to get set up and ready for that first local authority financial year.
So we've had a question about the DFE framework. So I don't know if we'll be able to answer this, but if we follow the DFE framework, would we be confident that we are following the new procurement regs?
We would certainly hope so. I think you would need to be careful that they are in tune with the new regulations. The new Procurement Act. It is important. Remember that the risk of it going wrong sits with you. No matter who says anything, no matter who says no, this is an entirely compliant process. If it transpires that it's not, it is going to sit with you. I would expect the department's arrangements to be in place. If the framework, as I said, if a framework has been already set up and structured and is in place now or is in place before October, that's going to continue to be covered by the existing regulations. So what you would need to be concerned about, and we haven't seen anything to check yet, are frameworks that are going to be set up post the new regime coming into place.
If I can just add something, I think it's really, Matthew set out some very helpful tests in when you're looking to operate a framework, and whether it's DFE recommended or not, or in relation to any framework, I think it's really useful guide just to go through those framework tests that he set out earlier on in the presentation. I'd also add check that the duration of the framework is still live. We've had a couple of queries recently where somebody's been trying to call off onto a framework that actually expired, or actually that is about to expire. So that's an important point to note.
Just one other point, because it follows on from that and from what I was saying before about it remaining your risk. Beware of suppliers that say, I'm on a framework agreement, and then try and get you to sign up to their standard terms and conditions. Just because they're on a framework agreement does not give you any protection whatsoever. You have to go through that framework agreement, and that's something that that certain schools have fallen foul of in the past. It's very sharp practice by suppliers, but they know that the problem, if it arises, sits with you, not with them. We are, of course, cynical because we don't tend to get asked about things that go well.
So I think we've got a couple people who are new to a procurement role and are looking for a more basic overview of procurement and how we can help them with that.
I think it's something we could certainly look at. The role of procurement within the sector varies significantly from organizations which have highly experienced and skilled individuals who know how to operate procurement processes and do it on a fairly regular basis, down to smaller standalone schools and trusts who rarely get involved in procurement because it's not something that they do on a regular day-to-day basis. So it's certainly something we could look at to put in place the sort of, the introduction, starting from first principles and considering how best to do that. As I mentioned, there are ways to avoid a lot of the complications by using pre-existing framework agreements. The academy and maintained school sector is well served in most areas by having a significant number of frameworks set up and framework organizations. There are CCS, Crown Commercial Services, there's Crescent, there's Pelican, there's Schools Buying Club, there's YPO, there's ESPO, there's all sorts of organizations which are set up and structured, and other choices are available. But there are all of these things set up to help you by having other people carry out the procurement process. As I said, it's not a complete shield. It's not a silver bullet to say I've used something else which someone told me was compliant. But the sector does recognize that there are a lot of people who don't have the experience and knowledge to run a procurement exercise themselves.
But I think if there's enough interest, and we would consider running one, so please let us know if that's of interest to you.
Okay, so it looks like we've got okay, so we've just had one in. We are a small SAT and the majority of our contracts are below 25k for 3 years. Are we likely to fall within the Procurement Act?
No. I like these nice, easy questions. Yes.
I thought you'd like that one.
Yes, no, and I suppose following on from the previous question, the first thing to ask when it comes to Procurement Act, Procurement Regulations, is what's the value of the contract that you're letting? And generally, if you're looking at a value that's below 214,000 over the lifetime of that contract, including VAT, then you have much less of a concern to worry about. The only point I'd say on top of that is that you should, whether you're a standalone or whether you're a multi-academy trust, you should have an internal procurement policy, and that will set out the internal rules you have to follow. Usually it's bandings, contracts below 5,000, 5 to 10,000, 10 to 25,000, 25,000 plus, etc. So you should always follow your internal rules. And of course, it's about ensuring that what you are doing is getting best value for money. We sometimes forget about the intention of this whole sector, this whole area of procurement. And it is, however restrictive, however frustrating it may be from time to time, the principle of it is there. It's designed to try and ensure that you get value for money for the public pound.
Okay.
I think that's all that's all the questions. So I think we're going to leave it there. But thank you very much for your time and for listening.